Hello again, and welcome to another of Mosaic's coffee breaks. Mosaic is, of course, a collaboration of the organisations shown at the front of this presentation, and that collaboration focuses very much on the ownership issues associated with mid-market law firms. And when we say ownership, we mean everything associated with ownership, mergers and acquisitions, partnership structures, succession planning, partner exits, and everything associated with all of those issues. I hope you enjoy this broadcast.
Hello, everybody, and welcome to the latest Mosaic Coffee Break. We're going back to our roots and looking at the anatomy of a deal. And we're going to consider over a series of 4 webcasts the key reasons why a firm might walk away from a deal. And we're each going to lead on one of these. So the 4 main topics we're going to look at are issues arising out of the accounts, valuation issues, cultural issues, and issues arising out of due diligence. And our colleague Mark's going to lead off this episode 1 of 4 as we look at what might come out of due diligence and how an independent advisor can interpret what comes out of due diligence in a way that sometimes firms that are deeply involved in the deal can't work out for themselves. So Mark, you've recently written a blog on this, which we all enjoyed reading.
Thank you.
Would you like to summarize that for those people watching this that haven't read your blog?
Yes. I think we pride ourselves, all of us within Mosaic, at being really good at getting deals over the line and making things happen. However, sometimes as an independent advisor, we have to say we advise you not to do this. And I was thinking, I had one a couple of weeks ago, which was the first time in a while we've said to a client, we strongly advise you not to progress with this deal. And that reminded me of one I had 4 or 5 years ago, where again I said to the client, looking at this, I advise you not to progress. Obviously, due diligence is key, where you start looking at it's the first stage. Once you've got to heads of terms, is we ask a whole host of questions, and the accountants, we've got 2 here, will like to ask a lot of questions around the accounts. We're mainly focused on sort of the business side of things, looking at the contracts, looking at the employees, looking at the claims record, looking at complaints, all of these things. Is there anything in the running of this business that if the buyer goes ahead and buys it, is going to come back and bite them in the backside? And I remember years ago going to a talk by an insurance broker who came up with the great phrase that if you're buying a law firm, the biggest risk is in the basement. And I think it was quite a nice phrase in terms of, it's those 6 or 7 years of files that could come back, and if you become a successor practice, are going to cause problems for you. So, my starting point on due diligence is always to look at the last 3 years PII renewal forms to see what is the business doing, because assuming they haven't lied on their renewal forms, that should give you a really good idea as to what the breakdown of the business is, where the risks are, the complaints, etc. And I think the 2 that I've advised to walk away, one was a general sort of bad feeling of red flags that came up over time. I sent out my standard due diligence questionnaire, send me copies of this, send me copies of that. And firstly, they couldn't find anything. And you sort of go, that's a bit worrying. And then you get, if they employed 10 staff, we sort of got 8 employment contracts eventually. 2 were missing. The 8 were all in a different format. And everything we asked for, they weren't sure. You just got a feeling that this was a very, very badly run firm, and they didn't know how anything was happening. They didn't have any good processes. And the more you look at it, the more you realize that there is a risk to the buyer because they don't know what they're getting. And that wasn't necessarily a case that there was anything specifically bad in the due diligence. It's just, it wasn't there. And the risk to the buyer was, one, not knowing that what they're requiring, but secondly, I think a time risk in terms of if you're taking over a firm that is really badly run, you're going to have to put a lot of your people in it for quite a long time to tidy it up and to make sure that it's running smoothly. And my client there is a nice acquisitive firm that's done a whole series of deals over the years. I said to them, do you have the time and resource to put into this quite small deal compared to everything else you're doing? But I think this is going to eat time. Would you be better off focusing your time, effort, and cash on something that's going to be easier to integrate into your firm? And they decided to. The more recent one was where due diligence just showed up a major regulatory issue. And it was a sort of deep breath, ouch, regulatory issue, which made us think that there were big issues around compliance going on in the firm. And even if you could say, well, we could square this one off and deal with it, I think, you know, our concern was what else was going on, because it showed a completely lack approach to compliance. Plus, it was something that the seller hadn't reported to the SRA that they should have reported to the SRA. And if you then report it to the SRA, who go, ouch, this should have been reported, what the hell's going on? You're then going to get an SRA investigation, time consuming, difficult, etc. And does that then make the SRA look at the acquirer as well as the target? So all in all, the answer to that one was no, walk away at this stage, too much trouble. And I think, as I said in the article, we like to make things happen, but as independent advisors, our best advice on occasion is, I know you've spent money on this, I know you've invested time, walk away. And there's the whole FOMO thing, the fear of missing out, in terms of, yeah, this is, it ticks all these boxes, it's the right geography, it's got the right bolt-on services, there's a couple of good people, they've got some nice clients, let's do it. And it's quite difficult for us as advisors, certainly twice in the last 5 years, to go, no, our advice is leave it, walk away, invest your time and effort elsewhere.
Mark, can I perhaps pick up on two issues there that have come to mind? One is this whole question of the time and resource going into the deal. I've actually had one recently where we've been, a client of mine has been offered an acquisition, and because of the background knowledge of the firm that they're going to acquire, they know that that firm's systems and procedures are virtually non-existent. And whilst it looks a very attractive firm on the face of it, they have realised that they're going to have to put so much time into getting the systems up and running that they're not even prepared to enter into negotiations and initial discussions. So if you can get that information in advance of getting to HOPS, that's very, very useful.
Yeah, so I think you're right. Yeah, so there's key things you need to look at as soon as possible before you've invested too much in it, and getting a feel for the systems and controls and maybe any regulatory issues. But
and the other thing that you and I have debated is the whole question of contingency fees.
Yes.
I know my approach is I'm never prepared to do any more than 20% up and 20% down, because frankly, I believe any more than that is unprofessional. And even though our views won't change as a result, the perception of the client's mind might be that the existence of a big contingency will influence our decisions as to whether to go ahead with the deal or not. And I know you've got an even more stringent attitude.
Yeah, absolutely. Yeah, so my contingency level is about 0 compared to your 20%, but purely because of that I don't want anybody to think that my advice is influenced by whether or not I'm going to get a fee out of it. I have to say, I've looked at this, please don't do it. And
Mark, there are a lot of firms that do deals, not just in the legal sector, but M&A work generally, that work on much higher contingency rates, indeed fully contingent rates. And they include some of the top 10 firms of accountants.
Absolutely.
And top 25 firms of lawyers. So, Tom, would you like to just pick up here how you might take a slightly different view to Mark and Howard's contingencies?
I do occasionally work fully contingent. Only occasionally, it's worth saying, but I do. I think that it's about having that, as with all pricing conversations, Nigel, it's about having that conversation with the client, isn't it? And setting out what their expectations are and where value is for them. So I do very occasionally work fully contingent, but that isn't to dismiss Howard's and Mark's point. I completely agree with where they're coming from. And I do think that certainly I'm aware of some of those firms you've mentioned, Nigel, and indeed some others, where not only do they work fully contingently, but they work fully contingently all of the time. And so that does inevitably skew their existence because they have to get something over the line that month. Otherwise, they're not paying the wages. And it might well be your deal that they, nudge over the line against their better judgment. So I think, I don't think any of the points are invalid, but I do think there can be room for fully contingent in the right circumstance. And I think it tends to work best where you've got usually sellers where there is a very specific requirement. It has to be sold by day X because of whatever timeline reason, or it has to be sold for greater than Y pounds. Well, as long as the deal is over Y pounds, by definition, it becomes a good deal, doesn't it? Because we've already set at the outset that this is the threshold that we're already using. And if it's below that threshold, well, it's not a good deal. And so we're not going to do it.
But I think it depends, of course, whether you're acting for the buyer or the seller. In the scenario there where you're acting for the seller and the seller knows what they're selling, if the buyer presents them with cash on completion, the risk is very little. If you're acting for the buyer, then making sure that the buyer doesn't acquire something that is not what they think they're acquiring is much more problematic.
That's certainly true. And I suppose I'm interested as well, Mark, if I may. You were talking about, this is twice for you now in 5 years, give or take. And actually, on the one, it's terribly important to have independent advice for all the reasons you've described. But is the other side of the coin then not the quality of the advice is sufficient that most times out of 10, you find your way through whichever bit of treacle you've found? Is that not the other side of the coin?
Oh, absolutely. The legal answer to that, Tom, is indemnities. When we do the due diligence, we look at that, we put together a series of warranties, and if we discover something that really is, we're expecting an employment claim for something, you just put an indemnity into the APA or the SPA that says, if there's a claim because of whatever, the sellers are paying it. That's easy. So in a way, because you can quantify the risk, and as long as the sellers are up for the money, that's fine. It's where you discover something that even an indemnity isn't going to sort out.
I think where this is really interesting for us as Mosaic is it's bringing out the importance of the independent advisor role to bring genuine objectivity to a matter. I did a number of deals when I was a managing partner in private practice, very rarely involving an independent advisor, and at least one of them shouldn't have gone ahead. And an independent advisor might have waved a red flag at me, but you do get caught up in deal excitement. And you'll find almost any reason to keep ploughing on. On another, the other way round, sometimes you can get crucial information really, really early. I remember at one point we were offered a sole practitioner's firm. The sole practitioner had died. His executors offered us the firm free. So, gift horse being presented to us, we decided to walk up to it and open its mouth and have a good look at its teeth. We sent in 2 of our lawyers to look at some files under an NDA. And by lunchtime, they had both phoned me back saying, run away, run away, run away, because negligence had been found on file after file after file. And while, the thought of a 400,000 a year extra bit of turnover and a nice will bank sounded attractive in the first conversation, it didn't survive that first visit to the practice.
Now, can I jump in and do a horrible legal disclaimer bit here? You see, there's a real issue around, even with NDAs, sending, this was a long time ago, I'm sure.
Long time ago.
But you're probably breaching client confidentiality as a seller if you let somebody else look at those files without a engagement letter to the client that says we can show your file to regulators and
Yeah.
to potential merger.
I'm sure we took care of whatever the requirements were.
Oh, I'm sure you were, but just to our viewers, just
Yes, absolutely.
don't obviously go and look at files without the correct
Yeah.
paperwork in place, because the SRA will be unamused.
I get that completely. Mark, we've all had comments on your very helpful and thought-provoking report. Is there anything else you'd like to add to wrap up this session?
No. Thank you for listening to us as ever. But yes, be prepared to walk away is the key message, even if it is exciting.
Wonderful. Thank you very much, Mark. And thank you all for watching. Episodes 2, 3, and 4 will follow in due course. What things that come out of the accounts, valuation issues, and cultural issues. So until those, we wish you all a very pleasant week.
Bye.